legislative enactments necessary to provide funds for it. Well, that's where the action always is how much money will you provide for education? Never any implicit or explicit connotation or otherwise that the courts would have a role in enforcing a quality of education.
But if the constitutional framers had put the word suitable in, you wouldn't object to the court interpreting it in the same way.
If they had put the word suitable in, your question is, would we be objecting?
The court would then be involved.
Yes. I can't argue that these other sister states with such language, and there are some without language, I grant you, with some sort of language that is susceptible of the court, a direction of the court by the will of the people, that you manage some sort of qualitative standard of education. We would have a less strong, a weaker justiciability argument, and we would be forced to construe the term suitable.
Even if the term adequate were used, or adequate to the needs of the students, or something quite bland and perhaps facially unrevealing.
Well,
but you're asking us not to read the provision even to contain something that apparently unexceptional.
Well, unexceptional, except for the fact that we are the last state to enact an education article, and before us we have myriad, I suppose 49 other constitutional provisions with all of these terms in it. And instead what we say is free and public, and the General Assembly shall implement this principle by appropriate legislation. No invitation to the court by any such language. Whether there'd still be an argument, it was made in other states. We have an argument that there was a deliberate choice made, and this court's cases say, and the deliberate choice was made in light of our own history, which is to say that in Bissell and in the Ludlow Code, the legislature determined quality, and the courts had no role in that. The court's role, and it's an important role, it's a critical role, is in equality. And that is lacking in a number of the states that the plaintiffs say, well, there was no text, or they facilely found a qualitative determination standard of educational quality in their constitution. New York, South Carolina, North Carolina, they've had equality cases and said, no, there's no principle of equality to educational opportunity in our state. That's not in our history. That's not in our text. They don't recognize Horton versus Meskel.
I'm not sure where this gets us, but it seems to me that it can be argued that the concept of an equal educational opportunity is a more difficult, evasive concept than a suitable education or an adequate education. I mean, we can at least take a shot at what suitable education means. We might disagree, but I really don't know what equal education means.
Well, I guess I fundamentally disagree that it would be. Will it be difficult to determine what equal educational opportunity is?
The consequences of a judgment in favor of the plaintiffs I mean, I don't disagree with you that has, far-reaching ramifications. But just in terms of figuring out what it means, it seems to me it's arguably easier. Let me to interrupt you. You don't agree with that?
This is no. I think it may be a difficult determination comparing one to the other, and because there's two as opposed to one, you might be tempted as a court to say, I can assess what is suitable, but with no standards other than ones that are imported from the executive branch or the legislative branch, which is exactly, Your Honor, what you said in Broadly the court will not do. The court had before it a claim, by the way, a substantive Article 8, Section 1 case, on its own, unadorned by an equal protection claim. The plaintiffs misstate that this court's never had an Article 8, Section 1 case. That is Broadly. And Broadly said that we will not simply look to a statute, such as 10-76E, to make up the constitutional standard. That's what they're asking us to do, the state and the court to do with 10-4A, is to say, here's a right to a suitable education, here's a definition of that term, and put that in your Constitution. Nielsen says you can't do that, that statutes don't define the constitutional right. So I guess to get back to your, Justice Palmer, Your Honor's question, I actually, while it may be a very difficult exercise to compare the two, it is what courts do. It is, and they may need to come up with standards, and some people may debate what those criteria should be, but that's how courts.
At the risk of belaboring this, just one more moment. The problem I have is, it may be that courts and others are capable of comparing two things, even three things or four things, but we don't know what to compare. That's the problem. And that decision alone is you know, very, very difficult.
Right. But that's a reason for fleshing out what the constitutional right to equality is, not for recognizing and making up a new constitutional right.
Would you agree? I'm sorry, go ahead and finish.
I think Your Honor said that in another Geisler case in State versus Davis, where the argument was, for policy reasons, you should go to another test. And Your Honor said, no, that's a reason for tinkering with this other test. It may be that the test for equality has to be fleshed out as a constitutional matter. And there are other equality cases where that's going to be difficult as well. It's not just a question.
We've been fleshing it out ever since Brown, haven't we?
Well, I mean, education